Okay, chapter 15, page 443, the federal courts. However impressive the Supreme Court may be, it makes only the tiniest fraction of American judicial policy. The court decides a handful of issues each year, albeit often key issues, with some decisions shaping people's lives and perhaps even determining matters of life and death. In addition to the Supreme Court, there are 12 federal courts of appeals, plus a court of appeals for the federal circuit, 91 federal district courts, one of those is in Grand Rapids, and thousands of state and local courts. This chapter focuses on federal courts and the judges who serve on them, the men and women in black robes who are important policymakers of the American political system. The judicial system in the U.S. is, at least in principle, an adversarial one in which the courts provide an arena for two parties to bring their conflict before an impartial arbiter, a judge. So there are systems out there that are not adversarial. Adversarial mean against each other. There are systems where people will sit down and be more like what you would imagine a conflict resolution being. In Europe, you can look that up. The system is based on the theory or the hypothesis that justice will emerge out of the struggle between two contending points of view. The task of the judge is to apply the law to the case, determining which party is legally correct. In reality, most cases never go to trial because they are settled by agreements reached out of court. There are two basic kinds of cases, criminal and civil. In a criminal law case, the government charges an individual with violating specific law or laws, such as those prohibiting robbery. The offense may be harmful to an individual or to society as a whole. But in either case, it warrants punishment, such as imprisonment or a fine. A civil law case involves a dispute between two parties. One of them could be the government, suing the government, over a wide range of matters, including contracts, property ownership, divorce, child custody, mergers of multinational companies, and personal and property damage. Civil law consists of both statutes, laws based by legislature, and common law, the accumulation of judicial decisions about legal issues. With civil, there's two types. There's tort law, T-O-R-T-E, and nope, I have it backwards. Tort, T-O-R-T, no E. Tort with an E is the cake. Tort law is negligence, intentional, negligence, which would be unintentional, and then intentional would be just that. But tort law is suing someone maybe for babysitting, but then not paying attention to the kid, so the kid gets injured, something like that. And so tort law, and then on the other hand, there is contract law. So two parties come to an agreement, there's consideration, money usually, and somehow, some way, the contract is violated. Marriage falls under contract law and its own separate laws specific to that contract. Just as it is important not to confuse criminal and civil law, it is important not to confuse state and federal courts. The vast majority of all criminal and civil cases involve state law and are tried in state courts. Criminal cases such as burglary and civil cases such as divorce normally begin and end in the state, not the federal courts. So because of federalism, think back to chapter 3, state issues, state law, state constitution, go to state court. And federal law, federal constitution, go to federal court. Participants in the judicial system. Every case has certain components in common, including litigants, attorneys, and judges. In some cases, organized groups also become directly involved. Judges are the policymakers of the American judicial system, and we examine them extensively in later sections of this chapter. Here we will discuss the other regular participants in the judicial process. Litigants. The Constitution restricts federal judges to deciding cases or controversies, that is, actual disputes rather than hypothetical ones. Judges do not issue advisory opinions on what they think may be the meaning or constitutionality of a law. The judiciary is essentially passive, depending on others to take the initiative. They don't go looking for issues. The law is passed and then the Supreme Court does not make a decision. The Supreme Court or any courts only make decisions if somebody brings it to them. Being the litigants, bringing it to them. That's what they mean, that it's passive. It waits. If no one sues or no issue arises, then the law would naturally stand. Thus, two parties must bring a case to the court before it may be heard. Every case is a dispute between a plaintiff and a defendant, in which the former brings charge against the latter. Sometimes the plaintiff is the government, which may bring a charge against an individual or a corporation. The government may charge Smith with a brutal murder or charge the XYZ Corporation with illegal trade practices. All cases are identified with the name of the plaintiff first and the defendant second. For example, State v. Smith or Anderson v. Baker. In many, but not all cases, a group of citizens, usually 12, is responsible for determining the outcome of a lawsuit. Usually the plaintiff is actually called a prosecutor when it's a criminal case in the government. So the government is the prosecutor and plaintiff is civil, but they're referring to plaintiff as prosecutor and civil, criminal and civil. Litigants end up in court for a variety of reasons. Some are reluctant participants, the defendant in a criminal case, for example. Others are eager for their day in court. For some, the courts can be a potent weapon in the search for a preferred policy. Not everyone can challenge a law, however. Plaintiffs must have what is called standing to sue. Now, this is going to be a big deal. This is actually a good way for the courts to dodge issues. Does the plaintiff have standing to sue? So it's definitely a test question. That is, they must have serious interest in a case, which is typically determined by whether they have sustained or in immediate danger of sustaining a direct and substantial injury from another party, such as a corporation, or an action of government. Merely being a taxpayer and being opposed to a law do not provide the standing necessary to challenge that law in court. So in other words, I can't sue because I think the government's budget isn't spending its money properly. That has been ruled as not enough of a connection. I can't sue for you. If you don't want to sue, I can't sue in your name. You have to have standing to sue. You have to be, the issue has to pertain directly to you for you to have a lawsuit. The courts have broadened the concept of standing to sue to include class action suits. This is a test question as well, which permit a small number of people to sue on behalf of all other people in similar circumstances. These suits may be useful in cases as varied as civil rights, in which a few persons seek an end to discriminatory practices on behalf of all who might be discriminated against, and environmental protection, in which a few persons may sue a polluting industry on behalf of all who are affected by the air or water that the industry pollutes. In recent years, the Supreme Court has placed some restrictions on such suits. So you might end up like I got some money from Wells Fargo because I had a mortgage with Wells Fargo a few years ago. There was a class action suit about some of their practices. And then Wells Fargo, I don't know if Wells Fargo, if it was taken to court or if they settled, but regardless, because I fell within the requirements of that class action, even though I was not a participant, I got a check. Not that big of a check, but it was some money. Based on my overpaying in a mortgage a few years back. Okay, this next definition is a really big deal as well. This is another way for sometimes the Supreme Court to dodge cases. Conflicts must not only arise from actual cases between litigants with standing to sue, but they must also be justiciable disputes, issues that are capable of being settled by legal methods. For example, when we not go to court to determine whether Congress should fund missile defense, for the matter could not be resolved through legal methods or not. The case actually has to be able to be settled. Through court, there has to be laws that pertain to the issue. There has to be standing to sue, etc. Okay, other participants. So we first had litigants, now we have attorneys. Lawyers are indispensable actors in the judicial system. Law is one of the nation's largest professions, with about 1.3 million attorneys practicing in the US today. Access to lawyers has become more equal over time, but that does not mean that equality of representation is equal. The wealthy can afford high-powered attorneys who can invest many hours in their cases and arrange for testimony by expert witnesses. The poor are often served by overworked attorneys with few resources to devote to an individual case. Groups. Because they recognize the court's ability to shape policy, interest groups often seek out litigants whose cases seem particularly strong. Few groups have been more successful in finding good cases and good litigants than the National Association for the Advancement of Colored People, don't use those last two words, NAACP, which decided to sue the school board of Tobacco, Kansas on behalf of a young schoolgirl named Linda Brown in Brown v. Board. They went looking for cases. They actually found 5 different cases that fall under Brown v. Board. The NAA, and it was actually for Linda Brown's dad. The NAACP was seeking to end the policy of separate but equal, meaning racially segregated public education. And the NAACP legal counsel, Thurgood Marshall, believed that Topeka represented a stronger case than did other school districts because the city provided segregated facilities that were otherwise genuinely equal. Which wasn't the case in the other court cases that they were bringing in front of the Supreme Court. They weren't even equal. The courts could not resolve the case simply by insisting that expenditures for schools for white and African American children be equalized. The American Civil Liberties Union is another interest group that is always seeking cases and litigants to support in its defense of civil liberties. One ACLU attorney stressed that principle took priority over a particular client, saying that some of ACLU's clients are pretty scurvy little creatures. It's the principle that we're going to be able to use these people for that's important. The example would be freedom of speech. The ACLU will argue for groups that aren't particularly liked, like the Klan, Ku Klux Klan, and others, because the argument is about speech, not the people that they're actually are the litigants. This goes back, remember, to the interest group chapter. We're going back. This is a review. Interest groups use lawsuits. They use litigation to pursue their goals. And then this next part also showed up in the interest group chapter, but I didn't test. It will be tested now. Amicus Curiae, and I'm not even sure I'm saying it, friend of the court briefs. At other times, groups do not directly argue the case for litigants, but support them instead with amicus curiae briefs, which attempt to influence the court's decisions. Raise additional points of view and present information not contained in the briefs of the attorneys for the official parties in the case. In controversial cases, many groups may submit such briefs to the court. Groups presented 136 briefs in the healthcare reform case in 2012. So every interest group that finds the court case relevant, whether in front of an appeals court or the Supreme Court, will create a long essay, maybe with facts, hopefully with facts and statistics backing it up, create that long essay or booklet, small booklet, and hand it off to the court, hoping they will read it as taking a side with either side of the whether it be the plaintiff or the defendant, whoever's appealing or not appealing. We're not always sure that the courts read these briefs. They don't actually tell them. Only way you can probably really tell is either they talk about it later or they reference it in an opinion on a judge's opinion on the case. But it's not quite sure how much they actually read of them. All these participants, plaintiffs, defendants, lawyers, and interest groups, play a role in the judicial drama, as do, in many instances, the public and the press. Much of the drama takes place outside the courtroom. How these participants arrive in the courtroom and which court they go to reflect the structure of the court system. So that's where we're at now, the structure of the federal judicial system. The Constitution is vague about the structure of the federal court system, specifying only that there would be a Supreme Court. The Constitution left it to Congress's discretion to establish lower federal courts of general jurisdiction. Jurisdiction is your ability to hear the case. In the Judiciary Act of 1789, Congress created these additional constitutional courts, and although the system has been altered over the years, the U.S. has never been without them. The current organization of the federal court system is displayed below. Keep in mind here then, in Article 3, the only court mentioned specifically is the Supreme Court. All other inferior courts beneath the Supreme Court created by Congress. As you can see in the figure, Congress has also established legislative courts for specialized purposes. These courts include the Court of Military Appeals, the Court of Federal Claims, the Court of International Trade, and the Tax Court. Legislative courts are staffed by judges who have fixed terms of office and who lack the protections against removal or salary reductions that judges on constitutional courts enjoy. The judges apply a body of law within their area of jurisdiction, but cannot exercise the power of judicial review, finding the actions of the legislative or executive branch unconstitutional. I actually don't ask anything about these legislative courts. We're really going to talk mostly about what courts you normally think about, which are constitutional courts. I have, I believe, some notes that I will include that go over the specific order, the hierarchy of courts, state versus federal. It's notes that I did on my own. Please check those out to go over these pictures here, these different types of courts and the hierarchy. Moving on. In this section, we focus on the constitutional courts. That is, on the courts of general jurisdiction. District courts, Court of Appeals, and the Supreme Court. So I don't test you on the other ones either, which hear a wide range of cases. First, we must clarify another difference among courts, that between courts with original jurisdiction and courts with appellate jurisdiction. And again, jurisdiction is the ability to hear the case. You have to go to the right jurisdiction, the court with the right jurisdiction to hear your case. Divorce courts do not have jurisdiction over traffic law. Wrong place. Criminal courts don't have jurisdiction over civil law. When you're going to sue someone, you don't go to a criminal court. Jurisdiction is hearing cases and having the right to hear the case. So courts with original or first jurisdiction hear a case first, usually in a trial. These are the courts that determine the facts about a case, whether it is a criminal charge or a civil suit. More than 90% of court cases begin and end in the court of original jurisdiction. Lawyers can sometimes appeal an adverse decision to a higher court for another decision. We'll talk more about that, but original jurisdiction is the trial court. The courts you usually see on TV, the ones with the juries and the witnesses. And when they say determine the facts, when a jury makes a decision, they're making a decision on what the facts are. It doesn't matter if it's capital T truth facts. If they find you guilty, the facts are you're guilty, even if you weren't, and vice versa. Or if you're negligent, that's the facts of the case. They've determined that. That's the whole point of the trial court, determining the facts of the case. But there's also appeals, and you do not appeal on facts of the case. You appeal on process and law. Courts with appellate jurisdiction hear cases brought to them on appeal from a lower court. Appellate courts do not review the factual record, only the legal issues involved. People get this wrong. You cannot appeal a case because you were found guilty. I was found guilty, I want a do-over. That's not, the facts of the case are you are guilty because the jury decided that already. However, you could appeal because, let's say you disagree that your testimony, your confession shouldn't have been admitted. Your lawyer was not, was sleeping through the entire trial. The jury was tampered with. Those are the legal issues involved. That's how you appeal. You appeal on legal issues, not on fact. Fact had already been determined by the jury. At the state level, the appellate process normally ends with the state's highest court of appeal, which is usually called the state Supreme Court. In Michigan, it is called the state Michigan Supreme Court. Litigants may appeal decisions from a state high court only to the U.S. Supreme Court, and only if they meet certain conditions discussed next. By far, that rarely happens. The U.S. Supreme Court rarely takes a case from a state court, believing that state law and state issues, because of federalism, should remain with the state. U.S. Supreme Court generally takes cases from federal courts. Okay, so we're talking about federal courts here. First, we're going to go over the district courts, which is called the workhorses. Then we'll do the Court of Appeals. We're in the Sixth Circuit. And then the Supreme Court. That will be what I do next here. Go over next.